during the break. We got a call from Kyle. Kyle, proceed with your call, please.
I was just going to ask, how long do you have to contest a will, and would the person misspelling their own signature be grounds for, the will being signed under duress? So if the deceased has been diagnosed with dementia, Alzheimer's.
I got you. Well, Kyle, I assume this may be in Houston County, so I don't know particularly. I know you're practicing in Florida.
Yeah, I'm licensed in Florida.
But as a general rule, I know there's time periods depending on once the will's been filed.
That's correct. And really, there's also not only once the will has been filed, but once you are served with particular
notice
pleadings through the probate system, that triggers some type of statutory deadline to contest it.
Right, but you mentioned something there. You mentioned something there, Kyle, about the dementia aspect. That's a bigger issue than the signature. I mean, the signature spelling could be an indicia of it, but the issue there would be if we could possibly show or establish something about your state of mind, because that's one of those more important things that you got to be able to make sure
that's right.
and take care of on those.
Yeah, you need to have full capacity to be able to enter into a last will and testament. And really what's tough about challenging capacity is when the individual who made the will has passed on, you're kind of left doing some detective work in retrospect. You're interviewing the medical professionals, the people close to that individual, and it's tough to challenge that. And that's also why it's important when we do these wills, we have these witnesses and notaries who are present, who could serve as fact witnesses, not the only witnesses.
Right, I've been through those kind of processes before, and you can get into an in-depth medical analysis and close in time and when those things have been diagnosed, and the general practitioner can become very important, loved ones can become important. In Florida, you can really have a lot of factors with respect to undue influence, which are also applicable in Alabama. So, Kyle, make sure and reach out to us, and we'll help you get in touch with somebody that can help you with that special issue.
Now, Ted, I will say too, just because a person has dementia doesn't mean that they can't enter into a will or a power of attorney. Dementia is it's a spectrum, and as we age and the dementia becomes more severe, obviously the lack of capacity increases, and so just because somebody has dementia doesn't mean they can't create a will, but that is a factor if you are looking to challenge the admittance of a will.